But going to the state level, this is another group of people that are among my favorites nationwide, and that is the North American Securities Administrators Association. They have an incredible Model Whistleblower Act that they've been fighting to get passed across the country, and it's really going to make a difference for local whistleblower protections. So I'm going to hand it off to our panelists, and I hope you enjoy this panel. Again, there'll be Q&A at the end, so stay tuned.
Thank you, Siri, and thank you to the National Whistleblower Center. We're excited to be talking to you about our efforts today. So my name is Andrew Hartnett. I am the Deputy Securities Administrator for the Iowa Insurance Division and the President-elect of the North American Securities Administrators Association, which I will now call NASAA. Sadly, not the space agency. Every now and then we'll have a member who tries to pronounce NASAA like NASAA or something like that to avoid the association with the space agency, but I'm not that good. I'm just gonna plunge on with NASA, if you'll forgive me. So organized in 1919, NASA is the oldest international organization devoted to investor protection. NASA's membership includes the securities administrators in the 50 states and the District of Columbia. State regulators are focused on grassroots investor protection and efficient capital formation. And as such, NASA recognizes the valuable contributions of whistleblowers. This panel is going to discuss ongoing efforts by state regulators to empower whistleblowers to come forward to expose fraud, abuse, and other misconduct in the securities industry. Our panelists are specifically going to talk about several state-level securities whistleblower programs that are in place now and encourage people to do the right thing in the unlikely event that they learn of potential violations of state and federal securities laws. Currently, only a minority of states, Utah, Indiana, Montana, Vermont, have established whistleblower programs, but these leading programs are an overwhelming success. Now, we'd like for today's program to be as interactive as possible, and we've included time for questions and answers at the end of the discussion. If you have questions during the panel, please go ahead and submit them in the chat function at the bottom of the screen, and I'll try to include them as I can as we go along or at the end. All right, so now enough from me. It's time to introduce my fellow state securities regulators and panelists that are actually going to be telling us about these programs and the important work happening at the state level. So today I am joined by John Cochran, the Commissioner at the Indiana Securities Division, Francois Grayson, the Director of Communication and Outreach at the Utah Division of Securities, and Emily Kosicki, the Director of Policy at the Vermont Department of Financial Regulations. All right, John, let's start with you. I've mentioned state securities regulators a couple of times. In my experience, people don't know who those folks are. So, tell us about state securities regulators and their work. You're on mute. You pulled a me.
Thank you. Sorry about that, Andrew. Thank you for the introduction. John Cochran, Commissioner of the Indiana Securities Division. State securities regulators play a critical role in protecting investors and maintaining the integrity of the securities markets. And as you mentioned, Andrew, that's important for efficient capital formation. Among other statutory responsibilities, the state securities regulators investigate violations of state securities law and bring enforcement actions when appropriate. Complaints often serve as the basis for beginning an investigation into possible securities law violations.
So how does the Indiana Securities Division, other state regulators benefit from whistleblower reports?
Well, first of all, whistleblower complaints can be a source of valuable firsthand information about wrongdoing in the industry that may not otherwise come to light. This information can be crucial in preventing harm and recovering ill-gotten profits or gains from wrongdoers. Unfortunately, just by the nature of whistleblowers, they often risk retaliations, and that can be significant, including loss of employment, being blacklisted, financial hardships, basically loss of livelihood. So to address this on the federal level, the SEC, Securities and Exchange Commission, administers a whistleblower reward program for those who provide information leading to the recovery of over $1 million in penalties. However, no such program exists for people whose reporting leads to smaller recoveries. So, that's where the states come in and kind of fill the gap. So to encourage reporters at that state level, some states like my own state, Indiana, and Utah have enacted state whistleblower programs to sort of fill that gap and provide protection and financial incentives for whistleblowers to report securities violations.
Awesome. All right, so let's delve into Utah's and Indiana's whistleblower program a little bit more. Utah established its program in 2011. Francois, would you tell us more about the Utah program and its backstory?
Sure, thanks, Andrew. I'm Francois Grayson from the Utah Division of Securities. So Utah's program is called the Securities Fraud Reporting Program Act, and it was enacted in March of 2011. It became effective in May of 2011. And so initially the act followed the model of the SEC Whistleblower Reward Program that was created in the Dodd-Frank Act of 2010. Our program was enacted following initial concerns that folks were pretty reluctant to report securities fraud to the division. So the basis of our program is that we will provide awards that are paid from our Securities Investor Education Training and Enforcement Fund. So our program also affords anti-retaliation protections for whistleblowers reporting original information, that's key, to their securities division if they're participating in any investigation or judicial action or an administrative action. But the program's main benefit is that it encourages people to identify wrongdoing in real time. So not after fraud has occurred and restitution is unlikely. So there's an emphasis there on being more proactive rather than being reactive. A lot of times when securities regulators receive complaints as well after the crime has been committed. So it can get people in the door. If it can get people in the door sooner, we have a much better chance of freezing the assets and getting restitution back to the victims. And if you are looking for any more information on Utah's whistleblower program, we do have that available on our website.
What was it like to get the act through the Utah legislature?
It received pretty much bipartisan support from our state legislator. The bill was sponsored by Senator Ben McAdams at the time, and then Representative Jim Byrd. And at the time, our Division of Securities Director was Keith Woodwell, and he spoke about the bill in the legislative committees. There were some early suggestions during committee to include protections for employers against illegitimate reports from employees, but those protections were added into the bill, into the final draft of it. But ultimately, the bill moved favorably through the legislature with the majority of the lawmakers voting for the bill.
So 2011, it's been over a decade since Utah's program was established. Can you tell us about the awards that have been made under the program?
Sure. So our act authorizes our Securities Commission to make an award to one reporter or several reporters who voluntarily, again, that's key, provides original information that leads to a successful enforcement action with a monetary sanction over $50,000. So our Securities Commission, it's made up of 5 Utah residents, their attorneys and licensees and other members of the public. So they'll make the decision about the amount of the awards that they would like to offer, as well as who the awards will go to. And to date, Utah has paid 3 awards to whistleblowers, and we're considering 2 additional awards to whistleblowers from separate enforcement actions. And so the first one that Utah awarded was in 2014, and it was a $15,000. And it was issued to an investment advisor who reported to the division. It was some questionable transactions, and it was about $100,000 that he had noticed in the questionable transactions. And the advisor told us that it was a Canadian national who was targeting a recent widow, and the widow had inherited a large sum of money. And the common theme that we will hear from a lot of these bad actors are promising low or high returns for very little risk. And that was the general story here. But of course, later in the investigation, it was revealed that the subject was actually spending funds on personal expenses as opposed to what was communicated to the investor. But generally, the division, we will present whistleblower cases to the commission that meet the requirements for an award.
Yeah, so $15,000, not in the same realm as $1 million, but those cases where they're spending money on their personal expenses are always so galling. So that's awesome. That's awesome. All right. So John, let's talk about Indiana a little bit. You've also established a whistleblower program. What tell us about Indiana's program?
Sure. Indiana's whistleblower award legislation was originally enacted in 2010 with House Bill 1332, which gave the commissioner of the Securities Division pretty broad discretion in making awards in an amount under, not to exceed 10% of the total monetary sanctions. This was re-examined 2 years later in 2012. And now it looks like it's in a format now that's more in line with NASAA and the Model Act and with the Dodd-Frank Act whistleblower language. I would say differs probably from Utah's program in that it only provides monetary awards to whistleblowers from the Securities Division's restitution fund. But it's in line with that. They're all in line with the NASAA Model Act.
Okay, cool. And we'll talk about that shortly. But before we get there, what was it like to pass the Indiana version? Was it like Utah's experience?
Very much like Utah's. Both bills enjoyed bipartisan support. The second bill, House Bill 1219, which was authored by Representative Bob Heaton, who's been a just fantastic champion for the Securities Division here, that passed nearly unanimously through both chambers. I think it may have had 3 no votes through the entire process. So very strong support for that.
Yeah, that's always great when you get numbers like that. So can you share some success stories from Indiana?
Well, we've only had issued one whistleblower award, but it was what I would consider a very large award. In 2016, the Indiana Securities Division awarded $95,000 to a whistleblower in connection with a $950,000 settlement with JP Morgan Chase Bank and JP Morgan Securities. The whistleblower was critical and assisted the investigators by providing information about improprieties in JP Morgan's asset management unit, enabling the division to bring an enforcement action against JP Morgan for failing to disclose certain conflicts of interest to its clients about the way the bank invested their money. It made a big difference, and I wasn't around in 2016 here at the Securities Division, but at the time of the award, the Indiana Secretary of State at the time publicly stated that without the individual coming forward, the office would not have uncovered the issue and Indiana investors would still be at risk. I would just, if anybody's interested in learning more about the whistleblower program in Indiana, I would encourage you to visit the Indiana Secretary of State's website to learn more.
Awesome. Thank you. So, as you can see, these programs have been successful. The cases that they're uncovering, the awards that they're offering aren't triggering that $1 million SEC threshold, but these are important cases, and investors are better off because they have been brought. The acts have been, the legislation has been supported by legislators on both sides of the aisle. And so for, what NASAA did is it thought, okay, more states may want to do this. Let's go ahead and establish our own program, a model whistleblower. Well, not our own program so much as, let's establish a model act that states can implement themselves. So the model act was informed by the Utah and Indiana laws. and passed by the NASAA membership a couple of years ago. So, Emily, can you, at long last, we have brought you into the conversation. Can you discuss the NASAA's Model Whistleblower Award and Protection Act and its backstory?
Yes, I'd be happy to. Again, that's Emily Kosicki, Director of Policy for the Vermont Department of Financial Regulation. We recently adopted the Model Act, and I'll talk about that more soon. The intent behind the Model Whistleblower Act was to help provide a safe environment for individuals to come forward to report suspected wrongful securities practices to state securities regulators. It was developed in 2019 and 2020 by NASAA's board-level state legislation committee. And it provides a state securities regulator with the authority to make monetary awards to whistleblowers based on the amount of monetary sanctions collected in a related administrative or judicial action, up to 30% of the amount recovered in that action. It also protects whistleblower confidentiality, prohibits retaliation by an employer against a whistleblower, and creates a cause of action and relief for whistleblowers that are retaliated against by their employer.
So can you tell us more about, you mentioned the state legislation committee. Can you tell us more about the committee and the process in which it developed the Model Act?
Yes. NASAA operates by committees that report to the board of directors. One of those committees is the state legislation committee, and I'm currently serving on that committee. So the model originated as one of the state legislation committee's projects. And when developing the Model Act, the committee consisted of state regulators from the District of Columbia, Indiana, Maine, Massachusetts, Minnesota, Montana, Ohio, Texas, Washington, West Virginia, and Wyoming. I wasn't on the committee at the time, but you can see there's a great representation of different jurisdictions there. It used a robust stakeholder engagement and public comment process to develop the Model Act. In April 2020, the committee circulated a draft of the Model Act for internal comments from NASAA member jurisdictions. In May 2020, NASAA released a draft of the Model Act for a 30-day public comment period. And when preparing the final version of the Model Act, the State Legislation Committee considered feedback from state securities regulators, investor protection advocacy organizations, trade associations representing the broker-dealer industry and investment advisor industry, private legal practitioners, and academics. Then the membership voted and adopted the act in August 2020. It's now available to any U.S. jurisdiction to stand up its own whistleblower program based on the act. And the act may be adopted as legislation during a state legislative session, or it can be adopted by regulation. Whether adoption by legislation or regulation, it depends on individual jurisdictions. And when jurisdictions consider the Model Act as legislation or regulation, they might also need to consider small tweaks that they need to make to the model as appropriate for their jurisdiction.
Awesome. Thank you, Emily. So, John, all right, let's talk about some of the Model Act's key features. You described the key components and how they empower whistleblowers to report wrongdoing.
Certainly. The Model Act has 6 key features that are designed to encourage employees and others to provide valuable firsthand accounts of financial fraud or wrongdoing to state officials and their employees. I'll go over the first 3 and then I'll hand off the remaining 3 to Francois. So number 1, the first component is fully operational upon enactment. So the act is intended to allow states, as Emily said, to stand up a fully operational securities whistleblower program upon adoption by the legislature without need to promulgate rules or do any further rulemaking. However, there is an optional provision included in the Model Act to provide state regulators with the express rulemaking authority. The second key factor is eligibility requirements for rewards. So it sets those out fairly clearly. To qualify for an award, the reporter must fall within the definition, obviously, of a whistleblower and satisfy the reporting requirements listed in the act, which has to be in writing and in a manner that is, or in a manner that's set by the regulator. The whistleblower must provide original information about a violation of the state securities law to the division to be eligible to receive an online awards. So what is original information? Original information means information that's one derived from independent knowledge or analysis of the whistleblower. Two, it's not already known to the state securities regulator from any other source. Three, is not exclusively derived from an allegation made in an administrative or judicial hearing, government report or hearing or audit or investigation, or from a news media source, unless the whistleblower was the original source of that information. And four, it's information provided to the state securities regulators for the first time after the date that the act was enacted. So it doesn't go retroactively to make awards to those who may have qualified, but were 5 years before the act was enacted. So the original information must be obviously accurate and truthful and lead to a successful enforcement action by the state. The third key component is it lays out who is not, who's disqualified from receiving an award. The Model Act disqualifies explicitly several categories of individuals who are ineligible, including individuals who are convicted of a felony in connection with the administrative or judicial action, the matter at hand, make false statements as part of their submissions, or have a legal duty otherwise to report. So none of those folks would be eligible for an award. And I'll hand off the other three to Francois.
Thanks, John. So I'll cover the last three components of the Model Act. Those three components are determining the amount of the award, protection of whistleblowers and internal reporters, and then lastly, the anonymity of the whistleblower complaint. So in determining the amount of an award, the Act authorizes state securities regulators to issue monetary awards to qualifying whistleblowers, an amount set by the regulator that is between 10% and 30% of the monetary sanctions collected in the related administrative or judicial action. So within that range, the Securities Administrator has really broad flexibility to consider various factors to determine the amount of a whistleblower award. So those factors, they're not exclusive, and they include the significance of the information provided by the whistleblower to the success of the action, the degree of assistance provided by the whistleblower, the programmatic interests of the Securities Administrator in determining violations by making awards, and then any other factors that the Securities Administrator may consider relevant. And then for the protections of whistleblowers and internal reporters, there's a few things. Like our program in Utah, the Model Act protects people who provide qualifying information from retaliation by their employer. Retaliation would include things like termination, discharge, demotion, suspensions, threats, harassments, blackmailing, things like that. So the Act, the Model Act prohibits employers from retaliating against employees who do a few things: report a possible violation of state or federal securities laws, participate in an investigation or an enforcement action, make disclosures required or protected under the federal securities laws, or make disclosures to their supervisory authority on matters that are subject to the jurisdiction of the state securities regulator or the SEC. So it's also important to note that a person does not have to qualify for a whistleblower award to be protected under the Model Act. Anyone who is retaliated against can sue for reinstatement, for lost wages, for costs, for damages, and for other injunctive relief. And also the lawsuit has to be brought within 6 years of the violation or within 3 years of discovery if not within 10 years of the actual violation. And then the last component of the Model Act is the anonymity of the whistleblower complaint itself. A whistleblower has the option to remain anonymous, but if they do want to remain anonymous, they have to be represented by counsel, and they have to disclose their identity prior to receiving payment of an award. The option to file complaints anonymously It, in this way, encourages potential whistleblowers to come forward by reducing the risk of retaliation while ensuring that the award is not made to someone essentially who would be disqualified by the act. So the act also provides that the identity of a whistleblower is exempt from public disclosure. So for example, that's a potential, for instance, FOIA request on the federal level or a grandma request on the Utah state level.
I know, I've got to say, it gives me a little existential angst to see you guys handing it off, but without me being involved. I mean, what am I doing here? Okay, bad joke. Since the Model Act was adopted in 2020, 2 more states have adopted legislation. Since one of them is Vermont, this question goes to Emily. Can you tell us a little bit more about the states that have adopted legislation based on the Model Act?
Yes, Montana was the first state that used the NASAA Model Act to enact legislation that established a securities whistleblower award and protection program. It was H. Bill 64, the Securities Uniform Whistleblower Act, which passed in 2021. The bill passed favorably with strong bipartisan support in committee and both chambers. Even before Montana had formally launched its program in October 2021, an individual called the state securities regulator to provide information regarding a possible investment fraud before the legislation went into effect. You can visit the Montana State Auditor's website to learn more about Montana's program. My state of Vermont, I'm proud to say, passed legislation based very closely on the Model Act just in May of this year. We're currently working on setting up our state's whistleblower program that will assist our department in protecting investors in my state from being harmed. So this was part of Act 139 of 2022. And just some notes on how that went for us. It was really smooth sailing through our state legislature. It was packaged as part of our annual policy bill that we put forward every year. And so it wasn't a standalone bill. It did not receive a lot of attention. And I think that when we provided testimony on it in committee, it was received very favorably. And so, you know, it was a good experience getting that through this spring.
It's 3 for 3 for those keeping score at home. So, you know, whenever you're trying to pass legislation at a state government level and federal sometimes too, you know, money is always the issue, right? So some legislators have concerns about the cost, may have concerns about the cost of whistleblower programs. Emily, how does the Model Act address funding? And maybe I should broaden the question and just say, how do all of your state laws address the funding issue as well?
So funding sources will vary by jurisdiction, but state securities whistleblower programs can be low cost or deficit neutral. Vermont, we draw funds from it has a long name, the Vermont Financial Services Education, Victim Restitution, and Whistleblower Awards Special Fund, which is made up to 15% of the total settlement amount from state securities law enforcement matters. So there, you know, portions of awards or settlement amounts will go into that fund, which has a number of uses that we can draw on, including now for our whistleblower award program. To your second question, given the number of requirements that a reporter must satisfy under the Model Act, especially the fact that the information must lead to a successful enforcement action, it's not likely that the agency would need to worry too much about constantly maintaining a significant amount of funding to support the program or, you know, potential abuse of the program. And as Francois went over earlier, the Model Act set out several disqualifying factors that would prevent a reporter from receiving a monetary award, such as employees who knowingly or recklessly made a false statement, used false writing or document. And so those factors also would disqualify and deter those making fraudulent reports.
John?
I would add, just to add to Emily's comments, in terms of Indiana, Indiana draws from its Securities Restitution Fund to pay out awards on whistleblowing. And that fund is comprised of 5% of money received for deposit in our Securities Division Enforcement Fund. Our enforcement fund is basically half of all of our civil penalties that we have come into our enforcement fund. The other half goes straight to the state general fund. So we draw from money that ultimately comes from enforcement actions and civil penalties. There was an initial appropriation by the General Assembly in that fund, but they set up a funding mechanism based off of what we bring in and our enforcement efforts. And I would just add one more thing, in terms of costs. We've had a statute in place for 12 years now. We've only had one, and it made a big impact. But we get tips every day. We get complaints every day, and we start investigations based off of those. But we've only had one so far that actually meets the eligibility standards for the whistleblower. So it's not an everyday occurrence. It's rare, but when it happens, it makes a big difference, at least for Indiana. Most of it, there was an initial appropriation, but most of it is from money that we bring in through enforcement action.
Thank you. Francois.
Utah has a similar program. We use our Securities Investor Education Training Enforcement Fund, and that is funded by civil penalties and administrative fines from our settlements and administrative orders from when the division files against bad actors. And again, our Securities Commission, they're the one who will determine the amount of the administrative fine, and they usually use several factors that's outlined in our statute to determine the amount of the fine. And some of those are the seriousness of the offense, the deterrence effect, the harm caused, whether or not the subject cooperated, any history of other violations, things along those lines.
So before I jump to my next question, I just want to note that we're fast approaching the end of our planned questions, much faster than our the end of the panel. So if we've run through it too fast and you want to ask us questions, get your questions in, because we're gonna have time for Q&A at the end. So all right, so we've been talking about the state programs, which makes sense. We're state regulators. But in 2010, the SEC established a securities whistleblower program through the Dodd-Frank Act. And we've sort of alluded to this already, but let's, say it directly. Some might be asking, why would a whistleblower report suspected wrongdoing to a state program when the federal program exists? Emily, can you answer that question?
Sure. The federal government did a really great thing when it decided to create a federal securities whistleblower program. But the whistleblower program that's administered by the SEC is different from the NASAA Model Act in at least 3 ways. First, the SEC program doesn't reach securities violations that are exclusively based on state law. Next, the SEC's program has a threshold requirement that the monetary sanctions imposed and collected in the related action has to be 1 million or more for the agency to be able to pay the whistleblower award. There's no such requirement under the NASAA Model Act. So somebody with information about a lower level fraud could provide that original information to the state securities regulator and be eligible for an award. And last, the SEC's program and federal law generally do not protect so-called internal reporters from retaliation by their employers. These individuals who don't report the suspected fraud to the state securities regulators, but do report it at work. The Model Act would protect these individuals as well as whistleblowers from retaliation for doing the right thing and reporting potential wrongdoing.
Awesome. Definitely exciting that both federal and state programs are generating actionable original information that makes these programs so important and desirable. So, all right, as we wrap up, I have some final questions I'd like to ask our panelists. Francois and John, Utah and Indiana were trailblazers when they established state whistleblower programs over a decade ago. How can stakeholders in the whistleblower community help the states like yours spread the word about state whistleblower programs? Francois, let's start with you.
Sure. Okay. Well, NASA, for one, they've developed a lot of materials that talk about the success of each state's whistleblower programs, including legislative commentary, podcast, and a webinar briefing as well. I would encourage everyone to review those resources if you haven't already. And I would also encourage you to share those resources with your networks and to help raise awareness. I think a lot of actors and participants aren't aware of state whistleblower programs. So if we can get more information out and more advice out, then that's the best source in terms of getting the information out there to stop the bad actors. And I know that NASA has a bunch of resources on their website as well. I use it all the time when we go out and do outreach in the community. So kudos to NASA.
And to add to that, Francois, I would just say, absolutely NASA, great resource for the states. I would encourage anybody who's watching today to go to that website and see what resources they have. I agree. It's getting the word out at every opportunity, especially within the industry. Just day-to-day interactions with the securities industry to let them know, this exists. It's there for them, and just letting the public know whenever the opportunity comes up to do it. So it's just getting the word out. And even if they don't know, and we identify someone in the course of an investigation, may have information that could qualify, we certainly will, take every reasonable step to encourage them along the way to go ahead and take advantage of our whistleblower award program.
Thank you. All right, so switching to Emily. Vermont was the second state to adopt legislation based on the NASAA Model Act. Why was it important to Vermont to do so, and why should other states follow suit?
So I can't think of any disadvantage for a state to have a whistleblower program. I really believe that retirees, families, and whistleblowers across the country deserve state-level securities whistleblower programs. And that's why Vermont moved quickly to adopt the NASAA Model Act this year. Prospective whistleblowers who possess evidence of wrongdoing are faced with the dilemma of whether to remain silent or report. And, they could worry about sacrificing their current employment or future opportunities within their field. The offer of an award that's in line with the value of the information provided, along with protections from retaliation, that helps provide some incentive for them to come forward and feel more secure in doing so. Establishing a state program only adds to the enforcement toolbox that state securities regulators have and will lead to the earlier detection of state securities law violations, which will provide regulators with a fighting chance to act before the money's gone.
Okay, great. And so last question, I just saw a big one come in. So we've got a couple of audience questions. Last question for me before we get to the audience questions. So if the audience wants to learn more about state securities regulators or the NASAA Model Act, Emily, where can they find more information?
So more information on the Model Act, including the legislative text and commentary that states can use to help stand up their own programs. It's available on the NASAA website at nasa.org. And then for anyone watching, if you would like to get in touch with your state securities regulation, you can find that information on NASAA's website as well. There's a box called Contact Your Regulator, and you can see a map that will help you locate the contact point for each jurisdiction. So that's a great tool if you'd like to talk to them about or encourage them to adopt this Model Act, or just talk to them generally about, whistleblower or state securities law in your jurisdiction.
Okay, so let's start going through some of these, some of the questions from the audience. First one we got was, how do you work together to help each other pass laws? And Emily, you may want to, I mean, I think that, there's a certain extent to which, Francois doesn't come into Indiana to help exactly. A lot of that work is done through NASAA and through the state committee that helps sort of, put together the model legislation and, testimony in support of it and that kind of stuff. But I don't know if it's sort of the high level outline. I don't know if Emily or others want to add to that answer I didn't intend to give.
Yeah, so going back to that outline I provided earlier about that committee process, it's really collaborative among different jurisdictions to develop these models, which are really, again, a starting point or a tool for jurisdictions to consider adopting on their own, making any needed changes. But it also helps provide uniformity among the states if we're all adopting identical or similar programs, like similar whistleblower programs in each jurisdiction. And then for how we help each other, once the model is there, we can help encourage each other to adopt it based on sharing experiences, hearing from other jurisdictions that have passed it, what were challenges going through the legislature, or, what are success stories that you can point to, and any data that comes in, like number of successful whistleblower complaints, things like that. And then just really education and outreach. So that's something, again, on the state legislation committee, we'll work to reach out to jurisdictions that might have questions or just provide information about models, to be there as a resource, really.
Yeah, and I would add that, engaging the legislature, the Indiana Securities Division, annually reviews its statutes and looks at ways to improve it. And so we're constantly engaging our legislators. And I think in terms of the national community and NASAA, just communicating what I'm hearing out there from our legislators, some of the objections that I may hear from my legislators could be very similar to those in other states. So it's learning off, its messaging, I think, is important. It's learning off of the experiences of other states who have been through this before. I would say I love the idea of Model Acts because it's, especially in NASAA, because there's been a lot of time and effort and thought that goes into it. And it's, you have a lot of very capable people who vet the language in there. So it's a great resource, these Model Acts for states that want to jump into something quickly and know that, this language has been out there and discussed and vetted.
So we got two versions of this next question, which is effectively, what can a person do? What can a person do to push their state to make better whistleblower laws, or how can people make their state use the law? Anybody have thoughts on?
Yep.
I mean,
call your state legislature, call your state legislator, your senator, and your representative, and tell them. I think is the first step, obviously, and contact your state regulator and encourage them to recommend that to the General Assembly or legislation. Whether it's I don't know how other states do it, but this Indiana Securities Division has a bill every year, and we're very active in the General Assembly. So we're constantly in communication. So I would go on both fronts and encourage both the regulator and call your legislator.
yeah.
And I would also say, when I've been going out in outreach presentations, Utah has the act, and so it's easier to talk about. But even if a state doesn't have the act, when you're going out in your outreach initiatives, you can always include the benefits of what the act, provisions the act provides, and also what protections it has. And so I include that as a part of our outreach, just to make sure the public is aware that this is available as a resource. But even if your state doesn't have a program yet, I think it still can be nice to get out there and share the information. from success stories from other states.
I was going to piggyback off what John said as well. You know, and a lot of, I think, regulators are thinking about whether or not to push a bill or what bill to push or whatever, knowing that there is a vocal group that is in favor of it can really be a helpful thing as you're trying to get the approvals necessary to push that bill. So, you know, I think that making your views and your, you know, the fact that you're in favor of it and going to be in favor of it and going to be backing the bill all the way through the process, those sorts of things can impact people's decision making. So, all right. So we had a specific question. Did the scope of the sanction against JP Morgan include just Indiana or other states?
Well, I don't know if it included other states. I just know about what happened in Indiana. To be honest, it was before my time here. I don't know if other states, my guess is there may have been other states that subsequently picked up on this and maybe took enforcement actions. But I think the important part is we wouldn't have known about it but for the whistleblower.
Right. When the
and
numbers
if that
were
started it off in other states, that's great, but it did come from a whistleblower and we wouldn't have known about it otherwise.
Right. And the numbers were that you gave earlier were Indiana specific, not sort of multi-state. So okay, a couple of questions about how the act would work. So you mentioned one of the disqualifiers for award is someone who is found to be untruthful. When is untruthfulness determined? And the questions sort of specifically in the context, I think the thought process behind the question, if I'm understanding it right, is, you know, an employer is always going to say that a whistleblower is untruthful. So how is untruthfulness determined?
Well, I can speak for Indiana. It's at the discretion of the commissioner. So it's determined before the award is made, obviously. It's truthful, I guess, until there's strong evidence that it's not truthful. But I mean, we do our due diligence on that. I know in 2016 we did our due diligence to make sure that everything was accurate and truthful, and it was. But that determination obviously is made in Indiana by the Securities Division and Commissioner before that's made, and there's fairly broad discretion in doing that. But you know, obviously we take our time to make sure that everything to verify the information that we get in any way we can.
I think from Utah's perspective is really just fleshing out the information during the investigation. And at least from our statute standpoint, it is considered a third-degree felony if you're untruthful during the course of an investigation, and certainly a whistleblower's contributions and reports and interviews would be considered in a part of the investigation. So that is a deterrent factor to be truthful during the investigation, but we do at least have that avenue to explore if it's found that they're not.
And in the Model Act, you know, it's knowingly or recklessly making a false, fictitious, or fraudulent statement or representation in connection with the original information. So, you know, I think that's a bit more specific than just general truthlessness. So it's, you know, knowing or being reckless with providing that false information. And again, in terms of timing, we don't have experience with this in Vermont yet because we haven't had any whistleblower complaints, but based on the way that the Model Act is designed, I would think it's, you know, just prior to making the award when, you know, the commissioner is doing their due diligence in making sure that all the criteria are met, and they would review carefully whether there was any reason to believe that there was false information provided.
Does there have to be a finding of that, or is it just at the discretion of the regulator? I'm just curious.
I believe it's at the discretion.
I know in Indiana, I think the Model Act sets a minimum of 10% and a maximum of 30. In Indiana, it's capped at 10, but no award is mandatory. So it's within if the commissioner feels like the person may have lied or may have been dishonest or if any other reason, the commissioner is not obligated or doesn't have an obligation or a duty to award it. It's purely at the discretion. I think that's one slight difference with Utah's and the model rule. So there could be a 0 award, even if they meet the eligibility requirements, but certainly it's in our best interest to encourage people to come forward. So if you notice our one award, it wasn't the maximum that we could award by the statute.
Yeah, I mean, it's easy to understand why you haven't faced this scenario. It's hard to imagine where somebody comes forward, it leads to a successful case, but they gave you false information that led to that successful. Like I'm sure I could come up with that fact pattern if I sat there long enough, but it's a little bit of a mind bender. So we talked about this a little bit running through, but I think it's a good thing to reemphasize. We got a question on it. So is there resistance to state whistleblower laws? Certainly, it sounds like the experience of the 3 of your states passing it the answer was really no.
No.
Yeah. No need to say more than that. Fair enough.
Yeah.
I would just say I did a little bit of research. There was very little debate or questions or very little debate on this part of the bill that this passed in. So I think the resistance was non-existent or very minimal.
I'd say here too, that was our experience, and I'm not aware of, resistance generally in other jurisdictions or nationally to these programs being put in place at the state level. And, we had some discussion about funding sources and pressure on our fund, but that was internal discussion and it wasn't coming from legislators. It was more us just, reviewing all of the uses of our own special purpose fund and determining whether this would have an impact. But that was part of our due diligence in, supporting this model act to our state legislature.
So we got one question about state securities regulators. Do you regulate insurance fraud related to fixed annuities or just securities?
I'll jump in first on that. In Indiana, it's just securities. Well, I shouldn't say it's just securities. We do loan brokers and others, but we have insurance has its whole other agency, and the commissioner of the Department of Insurance would make that determination. I really don't know the details of how they do that, but the Securities Division does not regulate that.
I think Utah is the same, but Vermont and I have a slightly different answer. So Emily, you want to offer that?
Sure. So I think the answer is it depends on jurisdiction, right? Here in Vermont, a fixed insurance product, isn't going to be regulated as a security. Variable annuities are, but we have an insurance division within the agency, the Department of Financial Regulation, that regulates both securities and insurance. So they are treated separately. It wouldn't be considered a securities product. So it's just separate divisions within the same entity that would cover insurance versus securities products.
Right. And but the Securities Bureau in the Iowa Insurance Division is in the Iowa Insurance Division. So again, the fixed annuity or fixed index annuity is an insurance product in Iowa, but it's still the Iowa Insurance Division that would respond to it. It would just be, well, if I point, you guys don't really know where I'm pointing, but it would be a bureau in a different part of our office rather than the Securities Bureau handling it. I think across the country, there's something 10, 13 that are sort of in the circumstance that Emily and I were just mentioning. And there's one or two, there may be a few other states at which the securities division, tries to regulate annuities. Sometimes that happens via supervision argument because it was sold through a broker dealer, or we won't go through a whole law school treatise on the various ways this happens, but the general answer is that that's left to insurance divisions. Sometimes securities and insurance are in the same office. Have you had any cases related to elder financial exploitation? That's certainly a big NASAA priority. That's another NASAA Model Act, actually, is on the subject of older American financial exploitation. I don't know if, John, you mentioned the one. I don't think that was older American focused. I don't know if you have an example you want to use, or if we should just say that we certainly see a lot of those cases, but the Venn diagram hasn't quite overlapped in this circumstance.
Yeah.
So, all right, I'm seeing my panelists nod their heads, so we'll go with my answer on that one. All right, so we're I'm going to ask one more question, and then make sure that I have correctly answered, that I have actually asked all of the audience questions we asked. But the one, and Francois, you were sort of getting at this a little bit earlier, but so you guys have passed the laws. Well, and Emily, you indicated earlier you're still sort of setting up the program, but what are your states doing to inform potential whistleblowers that the programs exist? How do you do whistleblower education, so to speak?
Yeah, I'm really just including it as a part of our outreach. Usually when folks reach out to the division and they ask us to come and do a presentation, they generally want a few conversations there. First of all, is who's the Division of Securities? Are they securities guards, or what do they do? So usually we'll give that sort of presentation. This is who the division is. This is the sort of cases we're seeing. This is how you submit a complaint. And we've just placed a bigger focus now on making sure we're explaining to them that this is an opportunity as well. I think some of the feedback that I receive from some of the constituents we talk to is that they're concerned with the anonymity of the complaint, or getting in trouble, or they don't want to report a friend or a neighbor or get them into trouble. And I think having those protections of the anonymity piece within the Model Act and within Utah's Act is helpful there. Another question they'll ask is, will we have to contribute to a criminal or an administrative proceedings? And usually if the case gets that far, they may have to take the stand or be subpoenaed. But I think the initial concerns is just whether or not I should even report it and being anonymous during that specific posture. So we've just been including it in all of our outreach. We're starting to build our social media platforms as well here in Utah. So we're including it in our messaging there as well. And that's really the best way we're able to get out the information.
I would just echo what Francois said, and having the opportunity to be here today and talk about it, as much as I have the opportunity to do, work it into our outreach, describe it on our securities portal, just every opportunity we can get to get the word out.
Okay. Well, that I think that takes us to time. So I want to thank the National Whistleblower Center and Siri. This has been great. We hope our panel inspires you to learn more about NASAA and state securities regulators and the model legislation, and the important work happening at the state level to encourage and protect whistleblowers. So thank you very much.
Thank you, Andrew.
Thank you. This was such an informative panel. I actually just had a quick chat with one of the interns working here in the office, and she said, wow, they have so much interesting things to say. So she was definitely keenly watching, and I could see in the chat there's a lot of active engagement. So thank you so much to all of you. I would like to encourage anybody to find out more about NASAA and what they have to offer. It's always a pleasure to work with you, and I hope we can collaborate together to help advance whistleblower laws on the state level, because they're critical, as your panel illustrated. So thank you so much.
Thank you.
Thanks.
Thanks, Siri.